Welcome to our session this evening. Apologies for the long break last night, but it was beyond my control. Hopefully we can proceed this evening. And we are going to be starting. Sorry, is someone speaking in the background?
Yes, we also apologize for the misunderstanding.
Thank you. We will proceed then today. I have apologies for the late start today as well. I have load shedding where I am currently in my chambers. It's supposed to end at 6, but it doesn't end at 6 exactly. So I'm using my cell phone, which is on a very low percentage of battery life too. So if I switch over later on, please excuse me in a few minutes time if there is a break in the transmission. Today we are going to try and cover as much as possible to make up for yesterday as well. So we are going to start off today with the parties. And you will find this on your program on page 4 thereof, where it says parties at the bottom of page 3 for day 2, 28 February, where it says jurisdiction continued, summons parties. Today I'm going to try to impart to you what must be contained in a summons and in particulars of claim. How you describe the parties therein, both the plaintiff and the defendant, and also on the aspect of locus standi. Right, now in the magistrate's court, you will either in an action or an application refer to a party as a plaintiff and a defendant, or an applicant and a respondent. Now these parties, in terms of rule 2 sub rule 1, remember I told you that you always need to have your rules close by as well as the act. Rule 2 sub rule 1 provides that the parties I've just referred you to, which is a plaintiff, defendant, or an applicant and respondent, will include their attorney or advocate who represents them or who appears for any of those parties. It will also include the official who is employed by a statutory body of any local authority, such as a municipality, who has been nominated specifically for that purpose by that municipality. That is reference to a local authority. In terms of rule 5 sub rule 4, it is very specifically stated what must be contained in every summons. In other words, there are no exceptions. This has to be followed to the T. First of all, the surname and the full names or initials of the defendant by which the defendant is known to the plaintiff. Now, I'm not really in favor of referring to parties by their initials, because as you will find out one day in practice, the entire household of one family may all have the same initials. And it may become a problem when you have to serve pleadings or any legal documents upon a person using only their initials. So by all means, try to get hold of the person's full names if you can. But if all else fails, you may refer to them by their initials as a last resort. You must also, in terms of rules 5 sub rule 4, in your summons, state the defendant's residence or place of business. And where it is also known, if you do know this about the defendant, you must also state his or her occupation and employment address. Then lastly, in terms of the defendant, if you are suing that defendant in a representative capacity, you must state which capacity you are suing that defendant in, as well as the nature of such representativity. And an example may be that you may be suing a defendant as the municipal manager of a municipality. There you will have to state that you are suing that person as a defendant in their representative capacity as municipal manager of the municipality, and not as in their personal capacity. Now, you must also state the full names, the gender, if the person is a natural person, and also the occupation and residence or the place of business of the plaintiff. And lastly, if the plaintiff sues in a representative capacity, like the example I just made with the municipality, you have to state which representative capacity that person is suing the defendant. Now, this is referring to the plaintiff now. Rule 6, sub-rule 12 of the rules provide that where a person is sued by a plaintiff as a cessionary, the plaintiff must indicate the name, the address, and the description of the cedent at the time of cession, as well as the date of cession. Now, a cession is where one party literally signs over the rights to either a contract or any document which is to benefit that person. That person is called a cessionary. And where that person is being sued as a cessionary, it must be indicated what that person's name is, what's the address of that person, as well as the description of the cedent. In other words, the person who's now receiving the right, and as well as the date of the cession. Normally, cessions are in writing, and it will therefore be easy to attach that document in support or as evidence of that cession. Now, it is further stated in the rules that every summons shall set forth the full names of the plaintiff. Now, the summons will be drawn up by either the plaintiff or the plaintiff's attorneys, which should both know their full names. So there's no way that your attorney will not know your full names if you are the plaintiff. And there's also no way that you will not know what your full names are as the plaintiff in an action. You must also state the gender. Now, these are compulsory issues. You do not have a choice. You have to refer, you have to make sure that your summons contains these things. The gender of the person, if it is a natural person. The occupation of the person, if must also be placed in the summons. You must also put in the residence or the place of business of the summons of the plaintiff in the summons, if you know. Obviously, you will know you are that plaintiff, or you are representing the plaintiff rather. And you must also state if the plaintiff is suing in their representative capacity, and then state such capacity. Other examples of representative capacity are as a curator, either ad litem or bonus. You need not worry about the differences now. Another example is as the MEC of a government department, the minister of a national department. There are various other examples of representative capacity. If you're a guardian of a minor child, that is a representative capacity. Now, coming to companies and closed corporations. a company or a close corporation is not a natural person, and therefore you cannot accord any personality to it like you would a natural person. In that instance, then, the company or close corporation must be represented by a person in the company. It will normally be either the managing director, the CEO, or the general manager of that company. In the case of a close corporation, it'll be one of the directors. But either of those persons who are now acting in their representative capacity will have to institute proceedings or defend such proceedings on behalf of those juristic persons by way of authority. They must be authorized to represent that company. So it cannot basically be the cleaner of that organization who now stands up and says, I represent Eskom, and I will be representing Eskom in this case. No, Eskom has a CEO, sorry, rather had a CEO. We don't know if Eskom has a CEO now, but whoever is the CEO of Eskom will be the person, the lawful person who is authorized to either institute or defend any legal proceedings on behalf of Eskom. Sorry, I know it's a bad example under the circumstances. And that authority that that person possesses to represent that juristic person is referred to in Latin as locus standi in judicio. It may be Latin, but it has become an acceptable term when we refer to the authority of a person. We still, amongst ourselves as lawyers, talk about locus standi. And literally translated, it means legal standing. In other words, your competence to appoint or represent a company or a close corporation. And the same would apply to government departments. There must be a person specifically designated or authorized with the required locus standi to represent or to institute proceedings on behalf of the MEC or the minister in the case of a national department. Now, it is normally assumed that all natural persons have the inherent right or authority to litigate. So they have automatic, all of us have automatic locus standi to litigate, to sue or be sued. However, there may be circumstances in which that locus standi may be defective or disabled in this, as is referred to in legal circles as well. Now, where there is such a disability, a legal disability of a person to possess full legal capacity or locus standi, that person may either be assisted by an appointed officer of the court, such as a curator ad litem, in the case of a person who is mentally disabled, a curator bonus also in the case of a person who's mentally disabled. The curator ad litem, by the way, is a person appointed by the court to represent the person and their rights in the possible litigation that may follow, either resulting from a claim against the Road Accident Fund, as an example, or from an appointment of, or rather in an estate where that person has a material interest. A curator bonus, on the other hand, and bonus is B-O-N-I-S, is also a person appointed by the court But in this case, the person will be dealing with the proprietary aspects of the person who has disabled locus standi. In other words, the financial aspects, if there is a claim paid out by the road accident fund, if there is a claim paid out by a person in respect of a successful claim, that money will be handled or managed by the curator bonus, who will dispense of the money in a responsible manner and report to the court on a regular basis. Now, a company and a closed corporation that we spoke about earlier on, these are examples of how they may be cited in, we are still talking about summons, and we will get to particulars of claim shortly. Now, in a summons, a company may be described as follows. The plaintiff is ABC Pty Limited, a company with limited liability, duly authorized and incorporated Can I please ask that we make sure that our mics are muted? The noises in the background are quite distracting. Thank you. Examples of citation of a company and a closed corporation in a summons. The plaintiff is ABC Pty Limited, a company with limited liability, duly registered and incorporated in terms of the statutes or company laws of the Republic of South Africa, with its registered address and principal place of business at 111 Naidu Street, Pretoria. That's a perfect example of how you describe a company. Now, an example of, and that is either as a plaintiff or a defendant, as an applicant or a respondent in application proceedings. We will deal with the differences between an action and an application soon. A closed corporation, an example of how you cite them in summons is the plaintiff and incorporated in terms of the Closed Corporation Act with the at 111 Naidu. Closed repealed. It no longer exists. The new provision for registration, they may,
Excuse me,
exactly,
advocate.
but they've been given as to until closed.
Your voice is fading, advocate. Yes. Sorry, your voice is fading, sir.
We've lost you, sir.
My electricity just came back.
Okay, thank you.
All right, can you hear me now?
Yes, sir.
Am I clear now?
Yes, you are, advocate. Thank you.
Much clearer.
Right.
Thank you.
Thank you. I had to change devices. The electricity only came back now. Thank you.
Yes, advocate, you are clear now, but we did not properly hear what you said about a minute ago.
I beg your pardon?
We did not hear what you said about 2 minutes ago.
About the closed corporation.
Closed corporation.
Closed corporation. All right, I will touch on it now. I was saying that closed corporations used to be registered in terms of the Closed Corporations Act, but the Closed Corporations Act has been repealed by the New Companies Act, in that closed corporations are no longer provided for. Rather, their their registration, but they may operate, those that are still in existence, but they only have a specific time within which to operate, after which no more, it will no longer be allowed for closed corporations to operate in South Africa. So there will no longer be a need for closed corporations, but for purposes of our proceedings here today, a closed corporation, should you happen to come across a closed corporation in which you have to sue, you will have to make the allegation that it was registered in terms of the Closed Corporations Act, which is no longer in effect. But you have to make the reference to it, because if it is still operating, it was established and registered in terms of the Act when it did exist. Educational institutions. Now, it's very important to know we are talking about higher education institutions here, and not schools in this instance. These public higher education institutions, take note, public, not private, they which were established in terms of the Higher Education Act 101 of 1997, they are considered juristic persons and they have locus standi. In other words, they can be sued and they can sue and be sued in their own name. Now, coming to public schools. Now, we are talking primary schools, high schools, but public schools, not private schools. In terms of Section 15, those schools are also juristic persons. In other words, they may be sued and sue in their own names. And an example of how you would cite a school, should there be any action against a school, is the plaintiff is the governing body of the Monument Park Primary School, a public school with juristic personality in terms of the South African Schools Act 84 of 1996 of Lewis Avenue, Monument Park, Pretoria. So it's important in your particulars of claim that you refer to the enabling legislation which establishes that juristic person as a school. In cases where the MEC for Education is being sued, or the Minister of Education is being sued, those are cases of vicarious liability where the department is being sued as being vicariously liable for the actions of the employees or the inactions of the employees of the department, such as you will see in cases of, for instance, medical negligence. The MEC for Health is sued because they are held vicariously liable for the actions or inactions of the medical staff at the particular clinic or hospital when the alleged medical negligence took place. Right, now, before the coming into effect of the Matrimonial Property Act in 1984, women had to get their husband's permission to enter into any contracts where they were married in community of property, right? Husbands, however, did not need to get their wives' permission to enter into any contracts. With the introduction of the Matrimonial Property Act in 1984 and an amendment thereof in 1993, the playing field was leveled now. Both parties needed each other's consent. And can you see 1993, with the coming into being of the Constitution, the interim Constitution rather, which gave every person the right to equality. There was a change now in that just as much as a wife in a marriage in community of property needed her husband's consent, the husband needed the wife's consent too. And that is still the position today, but only in respect of certain transactions. And an example would be a credit agreement in terms of the National Credit Act. You may not enter into such an agreement on your own if you are married in community of property. I'll take note, I said may. It may be happening that spouses are able to individually enter into credit agreements without the consent of the written consent of their spouse, but that does not mean that it is lawful. Right. In a similar way as a loan shark may not take the identity document of a person when they go for a loan. It's unlawful, it's illegal, but it is still happening. A minor who is a person under the age of 18 years of age is said to have defective locus standi, in that they cannot represent themselves in any legal transactions. They may not, in fact. And they may only do so when they become married, but they have to specifically apply to become emancipated. Now, the coming of age, the attainment of the age of 18 years of age is a natural thing with the progression of time. So automatically on your 18th birthday, you become a major or an adult. Before then, you are still considered a child. But if for some reason, and you may have come across this in your law of persons studies, for some reason when a minor, for some reason before the age of 18, acquires some sort of independence, such as losing both their parents and now having to fend for themselves at, say, the age of 16, and in order to do so needs to find a job, does find that job, is able to maturely, as a minor, perform mature acts. That person may apply to court to be emancipated from minority and to be given the status of a major person. In the application, that person will have to state facts in support of the relief of wanting to be declared emancipated. And if the court is satisfied that there are sufficient facts before it to support the relief that the person be declared an adult before reaching the age of 18, the court will so grant it, but the court will not consider it in a loose fashion. The court will apply very strict principles when assessing such a case. In any event, we've digressed a bit. So if a minor gets married to a person under the age of 18 gets married, and remember, they can only do so with the consent of their parents. So if a person's parents decide that that person at the age of 17 years of age is ready to get married to someone who's offered to marry them, and they've accepted that offer, the parents may consent to that person getting married at the age of 17. And by getting married, that person automatically acquires the status of a major. They're no longer considered a child in terms of the eyes of the law. So minors, on the other hand, again, if they want to institute legal proceedings, they must be assisted or represented by an adult who is normally the parent or both parents of that minor, who may either assist the child, as I said. In other words, they will sue as the parents, duly assisting the child, and the child will be cited in the papers. But our courts are loath to cite the full names of minors in court papers, especially where there may be adverse findings. Also in cases involving sexual conduct, the names of the minor children are withheld for obvious reasons to protect their identities. The same will apply in cases involving minors in civil courts, in the magistrates' courts, both the district and the regional courts. Right, persons who suffer from some mental incapacity do not have full locus standi. In fact, they do not have any locus standi. They may not represent themselves in legal proceedings, and they may not sue. They may not be sued, and they may not sue in any legal proceedings without being represented by either a curator or a guardian who has been specifically appointed by the court for that very purpose. And again, a guardian or a curator will have to apply on paper notice of motion with the founding affidavit to become appointed as the curator or the guardian of that mentally disabled person. That is called the curator ad litem. They will represent the rights of that person. I've referred to a curator bonus. In that same instance, again, will have to be a formal application brought by the person who is closest related to the person for an application, for an order to appoint that person as a curator bonus. And as I said earlier, to manage the financial affairs of that person. Do we have any questions so far?
Yeah, maybe just one question, Advocate. On this issue that you are raising in regard to mental disability, I'm looking at it and then also realize that case law in relation to this dates back before the Constitution. Now, among others, now we have the Section 9, which says, among others, we cannot discriminate on the basis of disability, in which case we are dealing with mental disability. I just want to check. I would imagine this is a common law principle. I just want to check. Post the Constitution, do we have any position in relation to that, or the common law principle still sticks, which was even adopted before the Constitution? Thanks.
Thank you. I'm not able to tell you offhand if that is the position or what the position is, but I will check it later on. I'm not aware that the common law is in conflict with the Constitution, but where you find that a legal principle has been in existence before the Constitution, if that common law position or legal principle is not in conflict with the Constitution, it will not change the position. Have I answered you satisfactorily?
Yeah, it's noted.
Thank you. I will check it up for you, though. Thank you.
Okay. Hello, sir.
I
Yes.
have a question, sorry.
Yes.
I'm working at the State's Attorney and we're dealing
Capacity
with,
to act. He cannot act. Not that he is discriminated, but he cannot act, doesn't understand. He is not well orientated, so he's lacking capacity to act.
Sorry, who is speaking now?
Sorry, I was trying to maybe to assist you. So sorry, Advocate.
Oh, okay. There was a lady
Yeah.
speaking, and then you spoke over her.
Okay,
Yes.
sorry. Okay.
May we have one person speaking at a time, please?
Okay.
I have a question with regards to subrogation. Why don't we need to put, like with session, why is subrogation different in your summons?
Ma'am, subrogation relates to insurance law.
Yes.
And it's totally irrelevant for our purposes. How do you mean it's different from?
Well, like you said, with the summons, you need to put all the details. Like with the session, you need to attach the session document.
Yes.
So subrogation, you say, is totally different. That's all I wanted to know.
Yes. No. With subrogation, as I said, it's with insurance law. And because the principles of subrogation are so clear and clearly established in terms of our law and already developed, there's no need to state subrogation in your summons when you are pleading subrogation.
Okay, that's all
Yeah.
I wanted to know. Thank you.
Thank you very much for your question.
Advocate.
Yes, sir.
Okay. Maybe when I was listening to the question by the gentleman, I don't know if I understood very well. Because when we talk of this case law, they are before 1993. So before our current constitutional law. But when you look at mental disability, I think they mean the person who's insane, who cannot understand, who doesn't have a capacity to act. So that person cannot take any decisions in terms of law.
Yes. Well, the question was relating to the cases that were before the Constitution. Should there not have been changes after the Constitution as a result of the Constitution having come into effect? And my response was, those cases before the Constitution were established and developed in terms of the common law. If those cases were not in conflict or are not in conflict with the Constitution,
How are you? Right. Shut. Let me try to do it. Take a 5.
Xulani, please, your mic. Xulani,
may I continue now?
please, sir.
Thank you. Can I please ask that we make sure that our mics are muted? It's distracting every time, and I have to restart something, and we already have to catch up what we missed out on last night. I don't want a repeat of what has happened before, guys. Please, let's respect each other's time. We are all benefiting here. So if, as I was saying, if the case law and the legal principles before the coming into effect of the present Constitution are not in conflict with any of the principles in the Constitution, then there is no need for the law to be further developed in terms of the Constitution. There may be specific challenges at specific times, but I'm unable to, at this point in time, say whether there were any specific case law, cases or judgments which came out after the Constitution was instituted. I think in all fairness, I would not have that answer right now, but I am willing to check it up for you. And hopefully by tomorrow, I can give you an answer, if that is okay.
Advocate, please, may I ask a question?
Yes, sir, you may.
Okay, please, when somebody has reached the age of majority as a result of a marriage, not because of age, can his or her name be also mentioned if there is a case of a issue regarding sexual offense?
Can you repeat the question, please?
Okay, I overheard you saying that when somebody is underage,
Yes.
during criminal proceedings or anything, his or her name may not be mentioned.
Yes.
Okay, thank you, sir. And then, but I'm trying to ask again that would the person's name who has now reached the age of majority as a result of marriage be mentioned in the case of any case of sexual offense?
No, for those purposes, that person's identity is still to be protected, even if they are now emancipated by way of marriage.
Okay, thank you, sir.
Yes, I think the courts will err on the side of caution and rather not mention someone's name. If it's an offender, then it's a problem. If the person is an offender and not the victim of sexual offense.
Yeah.
Yes.
Thank you.
Thank you.
As well as question, Advocate?
Yes, thank you. I'm going to take the last question now.
Okay, Advocate, I just want to check in terms of attaining majority by way
Yes,
of a person who's under the age of 18,
yes,
married, wherein parents consent to the marriage.
in writing, yes.
Oh, must it be in writing? And
It must be in writing.
Must also the court be involved when consenting to that? That's one question, Advocate. But my last other question, maybe I should have asked before you came to these other topics, is a question that relates to representative capacity. When
Yes.
I sue as a plaintiff on behalf of a particular company or institution, whatever you may call it, do I have to produce evidence in a form of a power of attorney? Because I've seen in some circumstances wherein when you ask to be represented, then those people who have to give information about you, they would sometimes demand that you give them a power of attorney as a proof that you've been duly appointed or you are duly representing a particular person. Thanks, Advocate. Those are the questions.
Thank you. Well, the first question is, the court is not involved when the parents have to consent to that person getting married. The written consent is required by the marriage officer who's going to conduct the marriage between the two. It is only when there is a dispute and the matter goes to court that it will be required that the written consent of the minors, of the parents of the minor child, will be required. Coming to your second question. Can you just remind me again, please?
Oh, it's about the power of attorney.
Oh, the power of attorney. Yes, thank you. Thank you for that. The power of attorney, previously it was a strict requirement that all persons who represented clients, attorneys, all attorneys who represented clients, be appointed by way of a special power of attorney. I still strongly advise that it is done today, although it's not compulsory, but a litigant in litigation between parties may at any time require, in most cases, the plaintiff or the applicant to provide authority that they are authorized to act on behalf of a particular client. But you must also be mindful of the provisions of the Poppy Act. Your attorney, although they may have a power of attorney, may not give out your personal information to third parties without your consent. So even though you may have a special power of attorney on behalf of a client, you must still be mindful of the provisions of the Poppy Act when it comes to disclosing information about your clients to third parties. Have I answered you satisfactorily, sir?
Yes, you did, Advocate. Thank you very much.
Thank you. There's a question here. If you have a claim, I'm going to take this as a last question now. If you have a claim against a CC, say for debt, how would we sue? I don't understand the question. Can the person who asked the question please elaborate?
Let's say there is a section 129 of the one.
I can hear you, but your line is not very good.
Oh my.
You may continue. Yes, sir. If you have a claim against a close corporation, say for debt, how would we sue?
Would you use?
Your line is very bad.
Would you use the Close Corporation Act, Companies Act, like for a debt, like which
you will refer to the Closed Corporations Act only for purposes of describing the closed corporation.
And then for the debt, saying that you have a debt, like let's say there's usually a clause in summons or particulars of claim saying that if you don't pay, we are going to, what's this one, liquidate you. Which act would apply?
The Companies Act will apply, sir, because the Closed Corporations Act no longer applies.
Even if it's a closed corporation, we're still going to use the new act.
The new act, yes. The new
Okay.
act provides for liquidation of closed corporations.
It does.
It does.
Oh, okay, thank you. I wanted to get clarity on this one.
Thank you, sir.
Thank you.
All right, let us move on now. We've got quite a bit to cover. Now, when it comes to juristic persons, in other words, not natural persons now, Rule 54 of the Magistrates Court rules specifies that actions by and against partners, in other words, partnerships now, a person carrying on business in a name or style other than his own name, an unincorporated company, or a syndicate or association, that is what we are referring to now as a juristic person. In that case, any two or more persons who claim or are being sued as co-partners may sue or be sued in the name of the firm of which such persons were co-partners at the time of the accruing of the cause of action. And I'll make an example. Before, it was not compulsory for law firms to be incorporated. You could form a partnership and you call yourself Naidu and Dlamini attorneys. That is a partnership. And where you may even have 10 partners trading or practicing as attorneys under that same name of Naidu and Dlamini. If you were to sue or be sued as that partnership, you could either cite two or more of the partners instead of saying you are suing the Naidu Dlamini partnership. You say Naidu, John Naidu and Sipho Dlamini hereby sued as partners in the partnership of Dlamini and as Naidu and Dlamini, situated at a firm of attorneys operating as such from this address. It will be sufficient if you sue both of them. In addition, you may also sue the partnership collectively by saying the defendant is Naidu and Dlamini attorneys, a private firm of attorneys in partnership at this address. You may not know all of the partners in the firm. But you need to mention at least two of them. So without you knowing, you have to inquire. Similarly, so when you don't know if an MEC of a department is a male or a female, go and check on their website. Nobody remembers all the ministers and know who they are. I sometimes make the mistakes of thinking that an MEC is a male or a female, only to find it's the opposite of what I was thinking. So go onto their website, the information is there. And we've also got Auntie Google, who will give us information freely. It's important that you know what the common law position is as well. Right, so partnerships, that deals with partnerships. Trusts. Now, trusts are a bit tricky. A trust is not a legal entity, or it does not have legal personality. So you must, in that trust, when you want to either sue as a trust or sue a trust, refer to the trustee. It's normally the trustee for the time being of the trust to be established, or this trust. So, or you must find out who all the trustees are in the trust. And that information is readily available from the master's office. And you will gladly be provided with the full information of those persons, provided, of course, you request it in writing, so that they know that it's a legitimate request from somewhere and not just somebody who's on a fact-finding mission. Now, in terms of section 41, more than one person may be a plaintiff in a case. Is there a hand up?
Yes, sir. Sorry to disturb you there. May I ask a question, if possible?
Yes.
With specific reference to trusts, we know that it can be difficult at the master's office to actually uplift a trust deed to get the names of the trustees. And I see on the notes they say it is necessary to join every trustee in their official capacities. Would it also suffice in your papers to just say the trustees of LP Majeke? Would that be fine?
No, sir.
Or okay.
You must mention them by name. And as you said, it's difficult to obtain trust deeds from the master's office. What you didn't say was it's impossible. It's not impossible. So as difficult as it is, you must remember you are representing your clients. And when the master's office is not willing to cooperate with you, you can report them somewhere else. It is their mandate and their duty to assist members of the public, especially when you have a legitimate request to want to know who the trustees are of that trust. Right? And that case of Mariola versus Kay and Eddie will assist you, because it will tell you how to go about meeting that requirement. All right.
Thank you, sir.
Thank you. Now, as I said, there is more than one plaintiff sometimes in a case. It's not necessarily one person who will sue, but you will find that 10 people were shot by the police whilst they were protesting. Each of those persons then institutes legal proceedings against the Minister of Police for assault, because they were all hit by rubber bullets. The Minister of Police then looks at this summons by each individual plaintiff and says, but this is the same cause of action. The same Minister of Police. Yes, different plaintiffs. They were all shot on the same day, the same venue, same location, and they are all claiming for assault against the same defendant. There, the defendant may, for convenience, bring an application to consolidate those 10 or 20 cases of those plaintiffs into one case, whereby you now have 10 or 20 plaintiffs in one case against the Minister of Police instead of 10 or 20 different ones, because the issue, the cause of action is basically the same. The facts are the same. The defendant is the same. The courts will, in cases like that, for purpose of convenience and to save costs, because instead of instead of 10 different judgments, there will only be one judgment should the matter be decided by the court. Or even settled. If the matter is settled, there will be settlement of one case only instead of the 10. So the court will, in circumstances like that, make an order to consolidate those actions into one. So you'll have more than one plaintiff now in the same cause of action. If, for instance, a party dies whilst involved in litigation, and I'll make the following example. The plaintiff is the mother of a child who was injured at a school, who is suing the Department of Education for the child being injured at the school. Whilst litigation is pending, the mother dies. That mother will therefore have to be substituted as the plaintiff in those proceedings. If there is a father, of that child, and that father now wants to institute proceedings in the place of the mother, in other words, substitute the mother as plaintiff, that party may do so by filing a notice to the court, by also notifying the other party or the other firm of attorneys involved that the plaintiff has died. Here's a death certificate, and she's now being substituted with the husband. Here is the marriage certificate, and here is his letters of executorship or authority as the representative of the estate of the mother. Right, I see Ilani Meyer has shared with us the Master's Office portal where you can verify or obtain information relating to any trust. Thank you for that, Ilani. I hope it's of assistance to the other colleagues. Right, we are now going to move on to forms of proceedings. Do we have a question?
Yes, may I ask a question?
Yes, sir, you may ask.
Yeah, I'm looking at the notes and what you are saying that trusts cannot sue, and so I have a question in the sense that in terms of the NPO Act, which is also a juristic person, which by law can sue or to be sued, and trust, I'm told, can also register as NPO. Now, so how do we deal with that element? Because one would think that if trusts are registered as NPOs, which can sue and be sued, but in terms of what we have here, or case law, even preceding the NPO Act of 97, it seems there's a position that they cannot be sued. So I want clarity on that. How do we work around that situation in an event where a trust is an NPO or registered as an NPO?
Okay, sir. I think we need to be mindful of the distinction here. The complete sentence says a trust cannot sue or be sued in its own name, right? So the sentence doesn't stop there with a trust cannot be sued. A trust cannot sue or be sued in its own name. It must be sued in the name of the trustees of that trust. Does that make sense?
Yeah, I get it.
Should I continue?
Yes.
Do you think I need to clarify it any further?
Can I ask a question, Advocate?
Okay, I'm still busy with one person first. I'll get to you now when we are done here. With regards to the question of the trusts and the NPO, are you clear now?
Yeah, I follow what you are saying, yes.
Do I need to clarify any further?
No.
Thank you. Next question, please.
Yes, I wish to actually inquire in terms of consolidation of a case in which there's a couple of either respondents or plaintiffs. If maybe for some reason, as you said, that you make that application, if the court refuses, to consolidate, those matters, is there any remedy?
Yes, if a court refuses an application, you have the right to appeal or take it on review, take the decision on review or appeal. The relevant principles will apply. Are you satisfied with my response?
Yes, thank you very much, Advocate.
Thank you. Right, now we're coming to, can I suggest a short 10-minute break? Comfort break. If we can all please come back here at 7:10 or 12 minutes past 7. So we can just take a quick body break. Thank you.
Thank you.
Thank you.
Thank you. We are back. Well, I am. Let's continue now with forms of proceedings. I'm not aware of what your notes look like. But I have notes. If I refer you to my pages of my notes, they may not be the same as your notes. So when you look at what we are dealing with, please look at the program that you've been provided with. We are now going to be dealing with forms of proceedings, which should be number 5. All right, number 5 on your program. And just another reminder, I'm not teaching you here, all right? I'm trying to apply the legal principles as practically as possible. If you catch me reading from the notes, I will plead guilty. It is because the notes set it out very simply, but I will try to provide practical examples of my own experiences and the way that I understand things to try and simplify them for you. All right, good. Now, we are going to be dealing with action proceedings now. You will have heard reference to, I will take legal action against you, or I will institute legal proceedings against you. These words are used often. And when they do refer to those proceedings, what they actually mean is there is a clear distinction that we have to keep in mind. You have action proceedings and you've got application proceedings, right? Page 74, thank you, Shirley and Molema. Now, action proceedings. In action proceedings, you have what is called a summons. A summons commences proceedings by way of action. The summons is a document, also referred to as a pleading, in which is set out the plaintiff's claim against the defendant. Now, action proceedings are preferred where it is anticipated that there is going to be a dispute of fact between the parties. And because there is going to be this dispute of fact, or it is anticipated there's going to be a dispute of fact, the plaintiff will have to, or the parties rather, will have to lead oral evidence, either by the plaintiffs and the defendants, or the witnesses or witnesses who will support their cases in court. There will be examination in chief, there will be cross-examination by the opponents of that witness, and there will be re-examination by the witness's legal representative. So that in a nutshell is how action proceedings take place. In application proceedings, it is totally different. And once again, in action proceedings, I've just referred you to where you have a summons, you have a plaintiff and a defendant as the parties. In application proceedings, the application proceedings have an applicant and a respondent. And the applicants and the respondents' cases are made out on the papers, which are in the form of affidavits. An affidavit is a statement under oath where you give your version. It will be written in the first person. I, the undersigned, hereby make oath and say, I am an adult male person practicing as an advocate. I reside at this address. I am making this application for the following relief. So it's written in the first person. And that constitutes the actual evidence in an application. There's no oral evidence in an application unless in specific circumstances only there is a need for oral evidence where it is discovered at a later stage that there is a dispute of fact in this case. It then will have to be referred to oral evidence either in total or on a specific or specific aspects of that case. But you need not worry much about it now. Let's just focus on the differences between an action and an application for now, the basic differences. Examples of applications will be found in terms of Rule 56 of the rules, where you have an application to the court for an order. The rule will tell you specifically what you need to do and what you need to, how you need to follow the rules, how you must make the affidavit, what you must put in the affidavit. It must be accompanied by a notice of motion. Then the next one is an interdict or an attachment or for a mandament van spolie. Those applications are all made in terms of Rule 55, and you have to consult Rule 55 when you want to draft that application to meet the requirements of the jurisdictional facts. In other words, what you need to prove in your application, you will have to consult Rule 55, which will tell you exactly what you need to put in your papers. And as I said, every application must be accompanied by an affidavit in which you state the facts upon which your application is made and the nature of the order that you want the court to give you. And I've given you an example of an affidavit. I, the undersigned, hereby make oath, and you describe in an affidavit.
Advocate, sorry to disturb. May I kindly confirm the previous point you made regarding interdicts, attachments? On the guide, it says Rule 56, and then I'm not sure if I'm mistaken, but I think I heard you say Rule 55. So if I can maybe get clarity.
Yes, no, all applications are made in terms of Rule 55 of the rules. That is the mistake. It's not 56, it should say 55.
All right, thank you.
Thank you for pointing that out. So it's in terms of Rule 55. And if you have your rules, you will also see that at the back of the rules is contained all of the sorry, that reference to Rule 56 is correct. But that Rule 56 provides for interdicts, attachments, claims, and mandament van spolie. But you must, if you read Rule 56, it makes a reference to Rule 55 because they are all made in terms of Rule 55. Apology there. That 56 is correct. Hello? Are you with me? Rule 56 is correct where it says interdicts, attachments to secure claims. But those applications are still made in terms of Rule 55. All right? Okay. Now we come to provisional sentence proceedings. Now, provisional sentence is a type of summons that you can issue against a defendant. Now, it's an extraordinary remedy because you can obtain a speedy judgment without having to go the whole expensive route of an illiquid, similar to an illiquid action where you have to call witnesses and apply for default judgment. In a provincial sentence summons, when you've issued it and the defendant has not defended the action, you may immediately apply for provisional sentence, which is the equivalent of a judgment against that defendant. So, and another advantage of a provisional sentence summons is the defendant cannot raise an invalid defense. They can't raise a defense that's not valid. It's only when they have a valid defense may they defend it. And the courts will frown upon a defendant who comes to court to defend a case without a valid defense. Right. Now we come
Advocate,
to...
Excuse me. Sorry. Could you give us an example of one of these proceedings, the application proceedings?
The application proceeding.
A practical one.
All right, we're still dealing with actions now. We will come to applications themselves. Then I will deal with them more fully. All right.
Thank you.
But there are certain actions. There are certain instances where you can only invoke action proceedings. And I'll make an example. And I'll come back to provisional sentence now. A provisional sentence can only be made in terms of a liquid document. Let's say, for instance, a check, although checks are not used anymore. If you have a check, somebody wrote you a check and the check bounced. You may issue a provisional sentence summons against the defendant for having written a rubber check or bad check. Attach the check thereto as proof. The check itself is evidence or proof of your claim against the defendant, and they cannot run away from the fact. In other words, there can be no valid defense for having written that very same check, unless they deny that they even wrote the check, that the check may have been stolen or something. So okay. In action proceedings, you may only use action proceedings, as I said, in specific cases. For instance, if you want to institute divorce proceedings, you may only institute divorce proceedings by way of action. You may not institute divorce proceedings by application. And that is because the Divorce Act itself specifically states that divorces must be handed down, must be instituted by way of summons only. Is the defendant given a 10 days period in order to defend the summons before a judgment is handed down? There's a response there, page 75, question there, 3 is an example. Let's go to 6. Okay, my numbering is clearly not the same. The instructor's notes and your notes are not the same. Now, when Teboga, are you answered
Page
now?
75, I was giving the example that you were referring to of the check. Question 3 on page 75 is the same example as the check situation that you were referring to. But the one about the number of days is mentioned somewhere in the study guide. I just can't find the page number now.
Okay. Just a moment for me. Just want to go to the precedents here. Forms. Original sentence.
Before it talks about the definition for court day.
Yes, court days are not public holidays or weekends. Court days are Monday to Friday, excluding public holidays and excluding weekends. So when you refer to court days, it's those days without excluding public holidays and weekends. I just want to get the relevant rule on provisional sentence, so I can give you a direct answer with regards to the days.
Advocates, I think it says 10 days.
Do you have the page number?
Well, I'm just looking at the court rules, and I see 14A, provisional sentence. And it says here, upon a day named in such summons not being less than 10 days after the service upon him or her of such summons to admit or deny his or her liability.
Okay, so it's a minimum of 10 days.
10 days.
But it may also be 20 days in terms of Rule 5, sub 1B. Because 1B provides for 20 days, up to 20 days. So as long as it's not less than 5 days, not 10 days, Tebogo. So it's unless it's not, it must not be less than 10 days, but you can give them more than 10 days.
Okay.
And then upon the expiry of those days, judgment is not automatically handed down. Should the defendant not defend the provisional sentence summons, the plaintiff must still ask the court specifically to give provisional sentence in its favor, which is the equivalent of a judgment. And it's similar to in a summons where a normal summons, a plain summons, a simple summons, or a combined summons, where the defendant has been served with that summons and does not within the required time honor the debt, the plaintiff has to still ask the court for default judgment. The court does not automatically give judgment. The plaintiff must specifically apply or request default judgment against the defendant. Okay.
Okay, thank you, Advocate. Noted.
It's a pleasure. Right, we will now deal more in depth with action proceedings. And then we will also have application proceedings at a later stage where we will be dealing with exactly how those proceedings take place. Or let's deal with applications now. An example of an application is the liquidation of a company. In terms of the legislation, a company may only be liquidated by way of application. So you apply to court on a notice of motion with the founding affidavit. And in there, for affidavit, you set out the facts. And just like we said in an action proceedings in the summons, you also have to describe the parties in a similar fashion. Remember now, an action and an application are both types of legal proceedings. And the way you plead your case is almost similar, except for in the summons, it's a pleading, and in your affidavit, you now write down in the first person as if the person is speaking. But you still have to describe the parties. You still have to make the allegation in an application that, in an affidavit, that the court has the relevant jurisdiction to entertain this matter and the basis for the court having jurisdiction, either because the respondent resides within the area of jurisdiction of the court, or the respondent carries on business, or the respondent is employed within the area of the jurisdiction of the court. And lastly, the whole cause of action arose within the jurisdiction of the court. Now, the applicant will then bring an application on the notice of motion supported by the founding affidavit, asking for the company to be liquidated. Now, the notice of motion will state who the respondent is. In other words, an applicant, there must be an actual applicant who is normally a creditor, who will make the allegation that the respondent company has committed an act of insolvency or is no longer able to pay its debts. I'm a debtor that have not been paid. The court will then look at that, and when the court is satisfied, the court will grant an interim order not a final order, an interim order to give the respondent company an opportunity to respond to the application, to either confirm that it is not able to pay its debt or to dispute that it's not able to pay its debts. Or it may even pay its debts and say the application does not find any application in court. If the court is satisfied that the applicant has made out a case on the papers, the notice of motion and the founding affidavit for the company to be late dated, and the company does not oppose that application, the court may then grant that application or that order as sought by the applicant in that application. Have I described it satisfactorily to the person who asked the question of an example of an application?
Yes, you did. Thank you very much. I appreciate that. Thank you.
Pleasure, ma'am. Right. Now,
quick question, sir.
Okay.
Did we jump action and move to application, or you were just explaining to the lady about application?
I was just explaining to the lady the application.
Oh,
yes.
we still continue the, okay.
Yes,
right,
we are. Joey?
Yes, Advocate, can you please explain to me the difference between prescriptions of the debt and superannuation?
I beg your pardon?
Prescription of the debt versus superannuation. I'm hoping I'm pronouncing it correct.
Where does that come from?
Look, if the plaintiff failed to what is this? To finalize the matter within the prescribed period, all right? And that period.
I lost you there, sir. Hello? I've lost you there. Hello?
It could be network problems, sir.
Yes. Okay.
Yeah.
Network problems. Okay, we'll take his question when he returns. Okay. All right, so we'll take, if you can hear me, I will take your question when you come back. Thank you. But for purposes of progress, we'll continue so long. Okay, now we said that an action may only be instituted by way of summons. Joey, are you still there? You are muted. That's why. Unmute. Okay, let's continue.
May I ask a question so long, Advocate?
Yes, sir.
Yes. Advocate, I just want to check is it possible that a matter that is brought by way of an application, as the matter progresses or even before it starts, there are elements of an action that are picked up and the matter can it be converted into an action when you started with an application?
Now, when you say before the matter starts, what do you refer to?
No, let me say, when the matter has already, the affidavits and everything have been filed, and the matter it's now starting in court. Now, the court picks up that there's evidence that will need to be provided orally. Can that be converted into an action? And will you not, as an attorney or a plaintiff, be punitively dealt with by the court that you brought an application instead of an action?
All right. Thank you for your question. I think I did refer to this earlier on, but just to clarify, where it becomes clear to the court, or the court is of the view that an application which has been brought to court now has or discloses or reveals that there are disputes of fact, material disputes of fact. That application, or the aspects of that application that are in dispute, will be referred to oral evidence. And you correctly said that that application will now be converted to an action. The provisions of an action will therefore apply in respect of discovery of documents and subpoenaing of witnesses who will testify at that, which is now a trial. And the applicant who brought the application to court will most certainly, in every single case, unless there are exceptional circumstances, be ordered by the court to pay the costs of the application of the respondents. So, as a way, it is punishment for the applicant. I am yet to see a court punish the legal representatives, because they are the ones who are in a position to advise the applicant whether to go action or application, because you cannot punish the applicant. In most cases, the applicant is a lay person who does not know the law and is guided by attorneys and advocates. They should be ordered to pay those costs and not the applicant. Have I answered your question satisfactorily, sir?
Yes, you did, Advocate. Can I just say this, Advocate? One last thing, that when you bring a matter as an application, that is a motion court, and when you bring a matter as an action, that is an action court. I'm not so sure if I'm correct by defining those courts in
it's
that
a trial court. Yes, it's a civil trial court and an motion court in terms of applications.
Okay.
Yes.
No, thanks, Advocate.
Thank you. We need to move on, please. Can we be a bit economical with the questions? Keep your question for later, sir. I will allow time for questions. I want to make sure that we cover sufficient material for the evening to make up for last night's loss as well. Please, if you have questions, keep them for later on. I will allow time for questions. Thank you. Right, now coming to action proceedings, we were saying that rules 5, 6, and 7 need to be consulted as to what needs to be put into a summons and the amendment of that summons before it is served, right? Prior to service thereof. We will deal with service later on. But for now, in terms of rule 5, every person who claims against another person may set out a simple summons or a combined summons, which is addressed to the sheriff of the court. And that summons is issued through the office of the registrar of the regional court and the clerk of the district court. And it directs the sheriff to inform the defendant that if the defendant wishes to dispute the claim and wants to defend the case of the plaintiffs in the summons, that defendant shall, within the time stated in the summons, do one of the following things. Give notice of intention to defend the case. And also, if the summons is a combined summons, within 20 days after giving such notice of intention to defend, the defendant must file a plea to the claim of the plaintiff. And in that plea, the defendant may also include a counterclaim if he, she, or it has a counterclaim against the plaintiff in respect of the same cause of action or a different cause of action. If the claim of the plaintiffs against the defendant is for a debt or a liquidated demand, you may use a simple summons. Now, a debt is considered a liquidated amount. This is reference to a liquidated amount, right? You may use a simple summons, right? Now, here are examples of a claim for a debt or a liquidated demand. An account and a debatement of that account, arrear rent, cancellation of a lease agreement, eviction in terms of a cancelled lease agreement, cancellation of a contract of sale, eviction based on cancellation of sale or conclusion of a new agreement. It also includes an interdict, failure to pay due maintenance, delivery of property and work done and material supplies. Here are examples of claims which have been held not to be a debt or a liquidated demand. So you need to be mindful of these ones as well, so that you don't make the mistake of classifying them as a debt or a liquidated demand. Collection costs, and these will be important when you as a debt collection attorney now want to take use a simple summons for a collection costs against your client, because it will have to be your client. The court will say, no, it's not a debt and it's not a liquidated demand because you have not proven that you are entitled to it. What if the defendant disputes it? Another example that is not a debt or a liquidated demand is payment of monies held to be due after debatement of an account. So the account having not been debated yet, you cannot know what the amount is. It's therefore not liquidated. Monies that are due by a deceased estate where the executor had excluded it in the liquidation and distribution account. You cannot know because it doesn't form part of the liquidated amount yet, of the estate, the value of the estate. The payment of a penalty, until you know the exact amount of the payment of the penalty, or whether you will be liable to pay that penalty, it will not be considered a debt or a liquidated amount, a demand. Every summons must be signed by the legal practitioner acting for the plaintiff, and that summons must bear the legal practitioner's physical address, which must be situated within 15 kilometers of the court building. On the summons must also appear the legal practitioner's postal address where it is available and if it is different from the physical address. It must also state the legal practitioner's fax address and email address. That's what electronic mail address refers to. And if the plaintiff is not represented by a legal representative, the plaintiff himself or herself must sign the summons. And the plaintiff, just like the legal practitioner, must also give an address in the summons, which is within 15 kilometers of the court building, as well as a postal address if it's different from the physical address. And the address that the plaintiff will give will be the address where they will receive papers in respect or notices in respect of the action in terms of the summons. Now, persons who wish to institute proceedings in their own personal capacity without the assistance of attorneys or legal practitioners are ably assisted by clerks of the court in the district court and the registrar of the court at the regional court. So if you do not want to make use of the services of legal representatives and you cannot afford them, either go to legal aid, or if you want to do it in your own capacity, you approach the clerk of the court or the registrar of the regional court, and they will assist you to draw up the documents and guide you in the right direction. But it must comply with these provisions of the rules. The clerk of the court or the registrar must then sign and issue the summons, and they will put an official stamp on there with the date on which it was issued, as well as a case number. It's very important that your document, your summons is given a case number, because that will tell you that it's now an official court document. Without a case number, it's not a valid document. And even without the court stamp on the face of that summons, it is not considered a valid document. Now, recently, especially with the advent of COVID, I know in Gauteng, they've been making use of case lines before COVID, but COVID has fast forwarded the procedure, the need for electronic service of documents. And a party may require another party to accept service via email. And that party may not unreasonably withhold consent to receive documents electronically. And where that party does refuse to accept or consent to service via email, the party so requesting may approach the court to apply for a specific order that the documents may be exchanged by way of electronic mail. It's just so much more convenient for parties to exchange pleadings and notices via email. Again, in terms of the rules, we are now still dealing with Rule 5. Every summons must state the following: the surname and names or initials of the defendant by which the defendant is known to the plaintiff, the defendant's residence or place of business, or where known, the defendant's occupation and employment address, and where known, the defendant's and employment address, and if the defendant is sued in any representative capacity, what that capacity is. Now, it's always, and I always say this, better to put as much information, relevant information, in the summons, as well as your affidavits in an application, because more information will make sure that you do not leave anything out. If you know where the person resides, if you know where they carry on business, if you know where they are employed, and all of that, what their occupation is, put all of that in the particulars of claim or the summons. You have a better chance of describing the person more fully if you put as much information in there than less. Also in the summons must be included a form of consent to judgment, a form of appearance to defend, a notice drawing the defendant's attention to the provisions of Section 109 of the Act, and a notice in which the defendant's attention is directed to the provisions of Section 57, 58, 65A, and 65D of the Act, in where the action is based on a debt referred to in Section 55 of the Act. Now, this information you will find when you look at the rules. There is a precedent of a summons, a simple summons as well as a combined summons. There's a publication by JUTA, which has both the Magistrates Court and the High Courts Act, as well as the rules in both courts. And at the back of the rules, both rules, you have forms of precedents, which show you exactly what a summons looks like, simple summons, together with all the information I've just referred to now. And the consent to judgment, form of appearance to defend, are all the things that the sheriff must point out to the defendant when the sheriff goes to serve the defendant with the summons. The sheriff must explain fully what the claim is about, how much it's for, who is suing who, what for, and how much. So the sheriff has a duty to explain all of those things to a person. If needs be, the sheriff must read out the entire summons with particulars of claim and explain it to the defendant. The sheriffs are specifically trained to be able to do that. That is their job. Now, where the defendant is cited under the jurisdiction which was conferred upon the court by Section 28 of the Act, the summons must contain an averment or an allegation that the whole cause of action arose within the district or the region as set out. And that averment or allegation must be supported by particulars in the summons. So we are now no longer looking at a simple summons. We are now looking at a combined summons. It's necessary for the plaintiff to make an allegation that the property is situated within the jurisdiction of the court. If it's not made, it's vague and embarrassing, or it does not disclose a full cause of action. And where the plaintiff issues a simple summons in respect of a claim, which is regulated by legislation, the summons may contain a bare allegation of compliance with that legislation. For example, if the plaintiff is suing the defendant in terms of Section 129 of the National Credit Act, the plaintiff must make the allegation that the plaintiff has complied with the requirements of Section 129 of the National Credit Act. But there is case law that says it's not sufficient for the plaintiff to make that allegation. The plaintiff must also state how they have complied with the requirements of Section 129 of the National Credit Act. Now, importantly, when a party brings an application or is suing a defendant for a debt, and as a result of the debt, the plaintiff obtains judgment against the defendant, and after judgment, then attaches immovable property and wants to now have that immovable property declared specifically executable, because you cannot execute against residential property without getting a special order from the court to give you permission to execute against that property. And it's for the simple reason that the persons occupying that property may have constitutional rights, will have constitutional rights, and it's up to you now to make them aware that they have constitutional rights. So you must in your summons draw the attention of those defendants to Section 26(1) of the Constitution, which gives them, everyone in fact, the right to have adequate access to housing. And some of the things that you need to address in there is that there are no elderly persons. There are no single parents living there with small children. Those are some of the allegations. And it is up to the defendant or defendants in such actions for such relief to claim or tell the court that, but this property being sold or declared executable will infringe upon our right to housing. But they must place that information before the court so that the court can consider all those facts before it declares the property executable. Okay, we are now going to look at Rule 6. That was Rule 5. You need to familiarize yourself with the contents of Rule 5 as well. And if you can, get a copy of Jones and Buckle, which is a very good publication on the Magistrates Court Act, as well as the rules. And both publications have got commentaries on both the Act and the rules, and they have all the relevant case law, updated case law on each of those rules and the sections of the Act. Right. Might now take a question or two.
No, yeah.
Whose mic is on?
Sorry, sir, I have a question.
Yes.
Are you saying that we're looking at Rule 5, Rule 5 of the Magistrate Court rules, or I'm mistaken? I don't know.
No, you are correct.
Oh, okay, so thank you.
Pleasure. There's a question here. What happens when you are more than 15 kilometers away? When you are more than 15 kilometers away, you have to appoint a correspondent attorney or a correspondent address that falls within the 15-kilometer radius of the court building. And yes, Petri answered that question. Thank you.
But in an event that you are representing yourself, does the 15 kilometers apply?
Yes, sir.
Advocate.
Yes.
Okay.
Advocate.
Yes, sir.
May you please repeat the publication that has the recent updated court rules and magistrate court rules?
Okay, I'm busy writing it on the chat now.
Oh, okay. Thank you.
Advocate?
Yes.
Can I ask you something? I hear you have been addressing the things that should appear on the summons. I need clarity. This section 4 signature of an attorney who has appearance, is it only for the High Court or is it applicable in the Magistrate Court as well?
In the High Court, ma'am.
Okay, thank you.
There are 2 volumes.
Advocate?
Yes, sir.
I've written my question on the chat with regard to prescription versus superannuation.
Oh, are you back now? Yes.
Yes.
Okay, let me see where it is. You've written it on the chat.
Yes.
Okay, I'm trying to understand. You want to know the difference between prescription and superannuation?
Yes.
Okay, in which context do you want to know about superannuation? Because as far as my knowledge, my limited knowledge stretches, superannuation is in respect of pension funds or retirement.
Maybe let's explain what I read. Let's say, for example, a client owes a shop for a period of time where the debt's prescribed, all right?
Yes.
And the company fails to act within that period. They only act after that period. And I read that then the defendant can then make use of superannuation to say, you can't demand or execute or attach my movable properties because you fail to act within the period as prescribed by the law of the prescriptions.
Okay. All right. My understanding of prescription, and please correct me if I'm wrong, if I understand your question incorrectly. Prescription is the time period within which you are to bring a civil claim.
Yes.
Now the Prescription Act 68 of 1969, Section 11 thereof, provides different periods of prescription for different types of debt.
Okay.
I know, for instance, where it has to do with a title deed of a property or land, it is 30 years. Where you are dealing with an ordinary debt, it's 3 years.
Okay.
So when a period of 3 years after the cause of action has arisen, and Section 12 thereof explains what is when a cause of action arises. It's when it comes to the knowledge of the person, the creditor, that they have a debt against, and they know who the debtor is as well. So because there's a Supreme Court of Appeal case which determined that it's no longer just a specific date. It's when it comes to the attention of the person. But our law was further developed now in the case of Links, where it said that there must be the person who claims to have come to have obtained the knowledge about the claim must do so within a reasonable period. You can't say, I only became aware after 20 years of the cause of action that I had a case against the department or whoever. That is simply not a reasonable period. And the example that was used was a woman who gave birth to a child with cerebral palsy. Surely, when she gave birth to the child and she saw there was something wrong with the child, she should have investigated then already whether there was anything wrong with the child. To only become aware after 20 years is not a reasonable time. That's what was said by the court in Links. It was not a reasonable time, even if the woman was a rural person, was not exposed, but each case will be decided on its own facts. But the gist of it is, you must, where it is so glaring that something had gone wrong, have done an early investigation yourself to inquire as to why something was wrong and what was wrong, and if anyone was responsible, why they were responsible. That is the issue of, that is on the issue of prescription. I'm afraid I'm going to have to read up on superannuation to answer you more clearly.
No problem.
All right, but are you covered by prescription?
Yes.
Okay. Is your question on superannuation related to prescription?
Yeah, somehow. If, for example, a default, a client default to pay, let's say 6 years ago, right?
Yes.
And the company fails to act legally, trying to retrieve all the processes that will allow them to attach and everything, and they only start now, 6 years later.
Yes.
Which will, in my view, will then prejudice the data in that regard. So will be within the legal regulations to do that, or legal prescript for them? Will the court allow them to continue with the matter and apply for judgment and subsequently to attachment?
Well, they will have to place sufficient facts before the court why they have not come to the court within the period. You know, before the claim is prescribed. They will have to put facts before the court to satisfy the court as to why they came to court outside of the period and why the court must entertain their claim.
Yeah, I think you don't need to worry to explain to me further. I think that answers my prescriptions versus superannuations.
All right, sir. But each case will be looked at on its own merits. It's not a hard and fast rule that because a person has not done anything for 20 years about the case, they cannot come to court. It's not an open and shut case. The courts our courts are progressive, especially in view of our constitution, and our courts accommodate persons, you know, who are not able to access justice.
All right.
But thank you for your question. It definitely challenged the mind. I'm more awake now.
Thank you so much.
Mr. Obakeng, you've been waiting for a while now.
Yes. My question is to, for instance, when you want to bring applications, or rather, when you seek an order to declare executable invulnerable property.
Yes.
I just want to know that such proceedings, do you only bring them through action proceedings or also application?
Right. Now, when it forms part of the action, right?
Yes.
It's part of your action, because you will have a summons which was issued and served on the defendant. The defendant does not defend the action. You then go to court to ask for default judgment against the defendant. After you've asked for default judgment, you ask then the court in the same application for default judgment in an affidavit, which in support of the application for default judgment, you ask the court that the property be specifically declared executable. So you can say it's an application within an action, an interlocutory application.
Perfectly understood.
Thank you, sir. All right, we'll take one more, Nchaveni. Nchaveni, you're not coming through. I think you're having connection issues, connectivity issues. All right, whilst we wait for Nchaveni to get connected, I will take two questions here from the chat. Milingoni, Simeon, you are asking what informs the 15-kilometer rule? The rules do, sir. The rules specifically state, Rule 5 specifically states that an attorney's office must be within 15 kilometers of the courtroom, or the address used by the plaintiff, if he or she is representing him or herself, must fall within the 15-kilometer range of the court. Anything beyond that, it means they must now appoint correspondents or correspondent attorneys. Shaheen Kara wants to know about condonation. What specifically about condonation, ma'am? Of the 15-kilometer rule. Shaheen? Okay, Jabulo wants to know, what if there is no attorney's office on that area? I doubt it. I doubt it. I doubt there are no offices no attorney's offices in the area where there's a court. Believe me, where there's a court, there will be at least one office of attorneys situated within 15 kilometers. You must remember, and I will make an example of the hunter and the hunted. Where the court is where things happen, so you can call that the prey for attorneys. So attorneys will definitely open offices in the area where the court is situated, so they can get the business, the prey. They can have access to the prey, which is at court. I hope I've answered your question, sir. But if there is no attorney's office in that area, then it will be understood. It will then make sense to the persons to come from outside and then act as they must find an address. It doesn't have to be an attorney's address. It can be any business address or any residential address for that matter, which is situated within 15 kilometers of that court. All right. Either in the case of attorneys or in the case of a person representing themselves. Now, condonation for the disruption of prescription. Or you mean the interruption of prescription? Prescription, people, can only be interrupted by a summons. A letter of demand does not interrupt prescription. You have to issue summons before midnight on the day before the cause of action arose 3 years later. Before the clock strikes 12 to say it is now exactly 3 years, you must have instituted proceedings. If you have not instituted your proceedings within that 3-year period, your claim automatically prescribes. But, and there's no condonation for prescription. Condonation is only sought in the event of non-compliance with Section 3, if you remember, as we said, of the Act 40 of 2002, Institution of Legal Proceedings, and where the facts will determine whether when your claim prescribes. We don't term it condonation, we term it establishing period. And if an accident happened on the 10th of May 2020, it will prescribe on the 9th of May at midnight 2023, which is when the 3-year period ends. But if the plaintiff only became aware of his claim or her claim on the 20th of May in 2021, because number one, he didn't know that he had a claim. Number two, he didn't know who he had a claim against. He must make those allegations in the summons when issuing the summons, and therefore state facts in the summons that the plaintiff only became aware that he had a claim. Although the accident happened in 2020, he only became in 2021 that he had a claim. It is on this date when he consulted with his attorneys, and his attorneys advised him that he has a valid claim, and he has a claim against the Minister of Police or the MEC for Health. So the facts will determine that. All right, so let's go. Okay. Does prescription apply in a context wherein X has unlawfully obtained a title deed of an immovable property? I don't understand the question. I need more facts on the prescription issue with the title deed.
Good evening, Advocate.
Good evening.
I'm asking in a context where I discovered that X has obtained a title deed of a house.
What are you to X? What is X to you?
There's no bond, no relation.
No relation at all. Okay. So X, how do you come? What do you become aware of it?
I become aware through neighbors that X is owning the house now. And when you confront X tells me that now the house he has obtained a title deed.
Is it your house?
It's my grandfather's house.
Okay, so X has got the title deed to your grandfather's house, but he obtained it unlawfully.
That is my presumption.
Okay. What then? What is your question on prescription?
Now I'm saying that if I claim the house tomorrow, will prescription apply?
When did it come to your knowledge that X had obtained the title deed?
I think in August last year.
Then prescription, if it is an issue, will start running from August last year.
Okay.
But it only becomes an issue when X says your claim is prescribed.
Even though we obtained it.
Then does prescription become an issue? If X doesn't say it's an issue, then it's not an issue.
Okay.
Whatever claim you have, you must make the allegation. I became aware in August of 2022 that X has the title deed and he obtained it unlawfully.
Okay. Thanks.
Thank you. Can I use combined summons for a liquidated demand? No. You have to use simple summons, but you may use combined summons, yes, but I would advise you to use a simple summons where you have a liquidated demand. But it does not mean you may not use a combined summons. But in a combined summons, remember, you must now put particulars of claim, add particulars of claim to it. What is the difference between simple summons and a combined summons? Sipo, go and read your notes, please. Okay. A simple summons has the particulars contained in the summons. A combined summons is accompanied by particulars of claim, which is a separate document.
Thank you.
What does vague and embarrassing mean? Okay. Vague and embarrassing means it doesn't make sense to the person who's being sued. Whatever is said in the particulars of claim or the summons does not make sense. It's vague and it's embarrassing. What are important facts to convince the court that will grant condemnation? In which instance, sir? The most important facts in condemnation to get for the court to grant it is that I only became aware of it at this stage, or I was not aware of it until this time. That's most usually the excuse given by a party for condemnation, or I did not know, I did not have the knowledge. Okay, there I see two hands that are up.
Yes, advocate.
Yes, sir.
In the event where the attached goods cannot cover the total debt, what then?
Then you send the sheriff back to go and attach something else.
Thank you.
Pleasure, sir.
Yes, sir.
Last question.
When it comes to, yes, that would be me. When it comes to the issue of prescription, let me give you a mini scenario. Let's say, for instance, I know that prescription is being interrupted by, for instance, issuing of summons.
Yes.
Let's say now I issue summons only to find out that I've issued it to the wrong person, or the person that I've issued summons to is not the correct party. Does it mean that the matter would have prescribed afterwards, or by merely issuing summons, it means that the prescription has been automatically interrupted, irrespective of whether I issued them to the correct party or not?
When you, as a plaintiff, decide to institute proceedings, it is your duty to ensure that you are instituting proceedings against the correct party. And if by the time you realize that you've sued the wrong party, the claim against the correct party has prescribed.
Yes.
Then, my friend, it is up to you to convince the court that your mistake was genuine and you did not know who the party was whom you had a claim against.
Or for instance, let's say that the defendant has provided faulty or wrong address and the sheriff goes there to issue summons, only to find out the defendant doesn't reside in that particular address. That's another example.
It's also your duty as the plaintiff to ensure that you have the correct address for the defendant whom you intend to sue.
All right.
All right. Thank you.
Hello. Hello.
That was the last question, sir. Who is it now?
Okay, so it's two last. Sorry, advocate. Just want to first something. If you are trying to apply for an attachment and then you are suspecting that someone might have moved a property to the relatives or some other way in order to try to hide that asset as if it's not belonging to the person. In that case, do you request further investigation or?
Okay, the answer is beyond the scope of what we are covering here.
Okay, all right. Okay.
I'm sorry, but it's taking our time now. It's eating into our time.
Okay.
All right.
Okay.
Thank you, sir. Okay. Now we are looking at Rule 6 now. We've looked at Rule 5. We are coming to Rule 6 now. And this is relating to pleadings generally, not just summonses, but you are going to find there are other pleadings that you file in civil proceedings, which are your plea, your counterclaim, your exception, your replication. Those are all pleadings that you are going to come across. And when you do draft these pleadings, you must follow the following. It is every pleading must be signed by a legal practitioner. If that person is unrepresented, then the party himself or herself must sign the pleading. Signature is very important. The title of the action describing the parties thereto, right? There must be a heading, in other words, of the document. It must have a case number at the head of each pleading. The correct citations of the headings must be used on all pleadings and notices. Very important that you refer to the correct court, the correct case number, the correct parties, and check the spelling of the parties. It is embarrassing to a party to write the name of another party incorrectly despite having a source or reference document already. Abbreviations may be used if the title is lengthy. Then you must make use of paragraphs, and each paragraph must be numbered, right? And each paragraph must contain a distinct allegation from the previous one. The pleading must contain a clear and concise statement of the material facts which you, now the person pleading, rely on. The answer to any pleading must be with sufficient particularity to enable the opposite party to reply thereto. In other words, if you are in your plea, pleading to paragraph 6 in the particulars of claim, you must clearly state that this response is in response to paragraph 6 of the particulars of claim, so that the plaintiff knows that he or she has to answer the same allegation in their replication if needs be. When you deny any allegation in any pleading, it must be clearly so. Must not be evasive. You must clearly say, I am denying. And then when you deny an allegation in a pleading, you must specify why you are denying that pleading. And when you rely on a contract in a pleading, you must state whether that contract is in writing or verbal. If it's verbal, who represented the parties, and give full particularity such as the dates, the place, and the material terms of that contract. If the contract is in writing, you must attach that contract to that pleading. All right, you must attach it. In the case of divorces, if in your summons now, or your particulars of claim, you are dealing with a marriage out of community of property. You must claim division, transfer, or forfeiture of assets. Now take note, this refers to marriage out of community of property, and yet they talk about division of the joint estate. This division here refers to marriages out of community of property with the accrual, right? Because without the accrual, there will not be division. And where it is with the accrual, the division refers to the amounts, the division of the amounts by which the larger estate has grown. And also marriages out of community of property, you must detail the grounds of the claims, right, against the defendant. You must give details of the grounds. For instance, if you are seeking maintenance for yourself or for the plaintiff must state on what basis the plaintiff is entitled to maintenance, right? If you are, in terms of Rule 6 now, pleading that in respect of damages, the defendant must be able to assess how much damages are being claimed. In other words, the quantum thereof. We are not talking the quantums with 4 wheels now that transport people. The word quantum here refers to the monetary value of the claim of the person suing. Next, if your claim is in respect of damages for personal injury, the following must be contained in your particulars of claim. Number 1, the plaintiff's date of birth, right? Remember, you're talking personal injury now. So it's important to know when the person was born so we can determine how old they are. And that's important in a personal injury claim because the person's life expectancy may be affected. And if the person is going to live until the age of 38, yes, some doctors are able to tell you what your life expectancy is. For children born with cerebral palsy, the life expectancy is about 24 years old. So that's important when you plead in those cases to put in the date of birth so they can determine what the age is of the person at the time of institution of proceedings until the life expectancy, amongst other things. You must also state the nature and the extent of the person's injuries, the effects and the duration of the disability alleged to give rise to such damages. And as you can see, a whole lot of other aspects have to be put into the summons when you are claiming in damages for personal injury. Where you are claiming damages from death of another person, the date of birth of that person is important, as well as the person claiming the damages as a result of the death. So the date of birth is once again important here too. Where you are relying on an agreement which is governed by legislation, you must state the specific legislation relied upon and the provisions and how those provisions affect your client's claim. Where the client is suing for cessionary, earlier on we did say you must mention the name, address, and description of the person ceding at the time of the cession, as well as the date of it. When you are suing on a contract, whether the contract is in writing or oral, as I've just said now, and the parties and what they need to prove. If in the pleading there's an allegation that there's a failure to comply by one of the parties who's pleading, the pleading shall be deemed an irregular step and the opposite party shall be entitled to act in accordance with Rule 60. So in other words, if the pleader fails to comply with these rules we've just mentioned now, by not, for instance, putting in the plaintiff's date of birth in a personal injury claim, the party receiving that pleading may say the court must declare this an irregular step in terms of Rule 60, capital A. So you can have that pleading set aside because it's an irregular step, because it doesn't contain a necessary averment in terms of Rule 6. Now, Rule 7 deals with the amendment of a summons. And this is before the summons is even issued by the court. And where such amendment is made, such amendment shall be initialed. And an example of this amendment is on the way to court, or rather after the summons has been typed out and signed and everything, the attorney reads it once again and sees a mistake and does not want to retype the document because the messenger is on the way to court and he's standing at the door. The attorney may make an amendment to that summons. Let's say it's the spelling of a word. Fix it by hand, but must initial where that amendment was made, right? So it's important that it is initialed by the person who signed the summons. Okay. Now, many papers that I've read, including summons and particulars of claim, it becomes clear that the attorney or candidate attorney who drafted these papers did not research the law before drafting them. Research, dear colleagues, is done before you before you draft the papers, because you have to know whether your client's case falls within the acceptable causes of action in terms of civil procedure. You must know whether you have good prospects of success. You can't just merely sit down at your table after consulting with your client and vigorously type out particulars of claim and a summons, and you say, right, let's go to court. Only to find someone, your opposition, filing papers to have your papers struck out for failing to disclose a cause of action, or merely raising a special plea and arguing a case which is totally against your client's case because you didn't research about it. So it's important that you do your research before you embark on any summons or particulars of claim, and make sure that you put in the essential elements on which you are relying in respect of the legal principle concerned. It's important that you know what your cause of action is before you institute proceedings. So when you are drafting pleadings, you must make sure that you must have due regard to the differences between facta probanda and facta probantia. Now, facta probanda is where the facts which must be proved in order to disclose a cause of action. That is what facta probandi means. Facta probantia is the facts which prove them. So what the facta probanda are in each particular case is a question of substantive law and not procedural law. In other words, what is the actual legal principle involved here? That is facta probanda. So let's look at some causes of action now, after we've seen what facta probanda and facta probantia is. A contractual claim, for instance, and a party who wishes to claim specific performance in terms of a contract now must prove that the contract actually exists. And the contract may be in writing or may be verbal. That party must also allege and prove the material terms of that contract. In other words, you're saying there was a contract for the sale of a motor vehicle. One, the plaintiff would sell to the defendant a motor vehicle. The motor vehicle was a Toyota Corolla 1999 model. The price was going to be 90,000 Rand. The price was going to be paid in cash on this date, blah, blah, blah. So they are the terms, material terms of the contract. You must also, in contractual claims, allege and prove that you have complied with the antecedent or reciprocal obligations. In other words, the plaintiff has complied with the terms of contract by delivering the motor vehicle to the defendant. The defendant has failed. Here's non-compliance now by the defendant. The defendant has failed to perform by paying the money or by returning the vehicle. In the circumstances, the plaintiff asks that for the return of the motor vehicle or for payment of the outstanding money. Both are specific performance. And the last one is costs. Costs is the most important part because that is how you get paid as a legal legal practitioner. If you don't ask for costs, you will not be given costs. It's important that you ask for costs. You cannot say to your client after you've won the case on their behalf, oops, I forgot to ask for costs and the court didn't give us costs, so you must pay me my full fee. What do you think that client is going to say? Oh no, I'm sorry. You didn't ask for costs. You're not entitled to costs. Simple as that. And there are other examples of what you need to plead in a pleading in respect of the different causes of action. I've just given you an example of delictual contractual claims. A delictual claim, you have to prove and allege something else. If there's a dishonored check which is against the drawer, those are the allegations that you must make. If you are claiming against a surety, there are specific allegations you must make. If you are claiming commission, if it's a claim for commission by an estate agent, you must make the following allegations: that there was compliance with the provisions of Section 26 of the Estate Agency Act with regards to the fidelity fund certificates. There was compliance with the requirements for the fidelity insurance. There was a mandate to find a purchaser or a seller and proof of that mandate. There was due performance of that mandate by the estate agent. And lastly, the commission that was payable in respect of the commission of the sale. So each cause of action has got different facts which you have to prove, allege and prove. Now, the interest rate is important as well, because interest in a claim for damages is informed by the contract, right? If there's a contract, and it normally becomes contentious in contracts where you have a mortgage bond will inform you. This is the agreed interest rate between the parties. A contract for a loan, National Credit Agreement Act, will specify the interest rate. So each one will have its own interest rate. In the absence of interest being specified or not known between the parties, parties are entitled to legal interest. Legal interest fluctuates with time in terms of the interest rate. For instance, every month or 2 months, I may be corrected, if every 2 months or so, the interest rate in the country gets adjusted according to the economic environment. And they will call it the repo rate. We have in South Africa something called a legal interest rate. And that is the rate which you are entitled to, the legal rate of interest. And it fluctuates and you have to familiarize yourself with it. At the moment, it is 10.5% per annum. In respect of contracts and interest rates, you have to also look at, especially the banks. The bank's interest rates are sometimes compounded daily. So interest runs on a daily basis. That's how banks make their money. One delay, are you sure it's 10.75%? Because I've got 10.5 here from the 10th of January.
Good evening, Advocate.
Good evening.
Yeah, it was recently hiked in Feb, if I remember correctly. There was another MPC meeting. It was hiked to 10.75.
10.75. Okay.
Yes.
So it's gone up by 25 basis points.
Yes, that's correct.
Thank you for that. So it's 10.75. I'll take your word for it. Right. Right now, Rule 9 provides for the sheriff to serve a summons or an application on a party. Only in exceptional circumstances, very exceptional circumstances, may someone other than the sheriff serve process or notices or other court documents. The sheriff is specifically appointed for the service of those documents. And there's a reason why the sheriff has to serve those documents. The rules, besides the rules specifically stating so, with the litigation can become quite hostile. And where it does become hostile, it will not be safe. I'm relaying my view now on why there's a sheriff and you can't go and serve documents. You will get there, and remember, litigation by its very nature is acrimonious. And when you arrive there, the person you are suing, you are giving them the document yourself. I am suing you for the 20,000 Rand that you owe me, and this is a summons. And if you don't pay this money, blah, 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 that person will become angry, punch you in your teeth for getting all up in their face about your own claim. That is why the sheriff is the only person to serve documents. And the sheriff has to go to is appointed by the Board of Sheriffs. And there is legislation in terms of which the sheriff is given certain powers. And some of those powers are the powers to serve those documents on them. And a sheriff must serve documents on a person by explaining those documents to the person very carefully, so that the person understands what is contained in those documents. They must also be given the option of going to an attorney to represent them. And you must explain that. The sheriff must explain that to the person who's being served with the document. And a document may be served by the sheriff personally on the person who's a party to the proceedings, or to their duly authorized agent. Right? But in order for there to be an agent, it must be a guardian, a tutor, a curator, or a like person, such as a minor, all right, or a person under disability. If the sheriff omits explaining the documents, then service is not proper. But the person who must allege that is the person who was served. The sheriff did not explain the documents. The sheriff must serve at the residence or the place of business. Now, the summons or the document that is required to be served on the person will provide for the full names of the person, the address of where the person resides or is employed. That's why it's important, as I said earlier on, to put as much information in your summons where the person resides and where they're employed. If the sheriff arrives at the person's residence and doesn't find them there, He will go to their place of work and find them there, hopefully, and then serve on them there. It's important for you to put in, now you should realize now why it's important to put all of that information in there. Domicilium citandi et executandi. Most of these contracts, usually by banks, contain a clause in which the party becomes the defendant now who's being sued, must give an address to the bank where they are domiciled. And the bank will normally insist, if it's an immovable property, like a mortgage bond, the bank will insist on that property, where that property is situated, being the domicilium address of the defendant, so that they can attach that, they will be attaching that property in any event. So they want that property to be the domicilium address of the defendant. That is what is referred to as domicilia citandi et executandi, the address where they will execute, domicile address where they will execute any documents. Okay, I'm just checking something quickly. Okay. All right, so just familiarize yourself with all the provisions of Rule 9 with regards to service. In cases against the minister or an MEC or a government department, the plaintiff may, in its summons, in his or her summons, put the address of the state attorney's office as the address at which they will accept service. In terms of the State Liability Act, the state attorney may be served with papers in respect of an organ of state. So just keep that in mind as well. But not municipalities, eh? Municipalities, although organs of state, they don't make use of the services of the state attorney. They have a fully fledged legal department, and they instruct attorneys on their panel to represent them in any proceedings against such municipality. In other instances, where there is pending litigation between two parties, the legal representatives of the two parties agree that either of them may serve documents upon the office of the other one should new causes of action arise. So they have a standing arrangement, but that must be in writing between the two parties, so there's no confusion. But with each new instruction or form of proceedings, there must be written consent that service may be effected on that attorney's representative by that attorney or by that client himself, the party. Right. Okay, before we...
I've got questions.
Before we call it a night, I will take a few questions.
I've got one.
Yes, sir.
What if the defendant cannot be found to sign acknowledgement of receipts of summons?
If the sheriff, if the person cannot, if who? The sheriff?
No, the defendant.
The defendant. If the defendant cannot be found.
Yes.
Then you have a return of non-service. But what you can do is you can instruct a tracing agent to find the defendant. And there are tracing agents around who will find a person for you. You'll be amazed at what people know out there and what people can do. They will find the defendant for you. And whilst you are at it, looking for the defendant, you ask the estate agent, the tracing agent, to do an assets check to see if they have any properties in their names. They are able to find those things, eh? Amazing enough.
Okay, all right. Thanks.
Is it on the deed search, sir?
I beg your pardon?
Is it on the deed search? Because you can also find whatever in a person's profile on the deed search.
Yes, if you've got access to it. Remember, not everyone has access to deed search, eh?
Oh,
it's a service that you have to pay for. And normally conveyancing attorneys have got access. It's a program that you have to subscribe to.
But I don't think you can deed search your movable properties unless vehicle, but furniture and fridges and so forth, you can't deed search that.
Yes, it's for immovable property and it's useful for that. But your tracing agent will be able to help you with immovable property and other stuff.
Okay, all right, I'm with you. Thank you.
Next question.
Advocate, I just want to check with regard to the issue of summary judgment. Is it only available to the plaintiff? Is it only available to the plaintiff, or is it also available to the defendant? Because I just want to make, for instance, a practical example. Say a plaintiff sends me the summons, your simple summons without declarations. Can I approach the court and ask for absolution of it? Because I can't ask for a summary judgment, but as a defendant, can I approach the court, ask for absolution? Or is only just available to the plaintiff, the summary judgment?
Okay, you are talking about two things. You're talking about summary judgment and you're talking about absolution from the instance.
Yes.
Summary judgment is an expedient remedy available to a plaintiff where there is a liquidated claim, right? A liquidated claim, and where the defendant has raised, has not disclosed a bona fide defense to the claim. That is when summary judgment may be applied for by the plaintiff, right?
Yes.
In the case of, you've jumped the gun a bit because tomorrow we'll be dealing with default judgments and summary judgments. I don't want your colleagues to be confused now at this stage. But absolution from the instance, pardon?
No, I was saying that it's fine. I will wait until tomorrow.
Yes, but absolution from the instance is what a party applies for when the opposite party has failed to prove their case after having led evidence in court. Then you apply for absolution from the instance.
Is it possible? Okay. Can I?
Yes, it's what possible.
Does absolution go with section 174, sir?
Section 174, you are referring to criminal cases now, ma'am.
Oh, okay.
That's a discharge.
Okay.
In terms of the ability and the capabilities of sheriff, are they obligated, to even carry out some unlawful instructions? For instance, where there's a writ of execution, obtained, illegal, if I can put it like that, by somebody else. For instance, when the matter is still going for appeal and so on, are they obligated to carry out and remove somebody's property, or do they have to use their own discretion?
If the sheriff is not aware that the writ was issued unlawfully, he cannot be held responsible for it. And he executes on that writ without the knowledge that it was issued unlawfully. The sheriff cannot be blamed. Remember, an unlawful issuing of the writ is the fraud of the person who sent the sheriff. Not by the sheriff, but where the sheriff is knowingly or willfully aware that the writ is illegal or unlawful, the sheriff is not obliged to act on that. But it must come to the knowledge of the sheriff that it's an unlawful writ.
Oh, so you don't need to actually apply for a formal, application to actually stay that writ, because that may actually.
You can, if it comes to your attention that there's a writ which threatens to be executed by the sheriff, you may bring an application to stay that writ on an urgent basis.
Oh, okay. Okay, thank you.
Especially if the sheriff is not aware that it's an unlawful writ. Because he's just doing his job, remember? Okay, next one, last
advocate,
one.
Yes, advocate.
Yes, sir.
Yeah, yes, advocate, if I may ask, it's actually a follow-up question on the issue of an evasive defendant who is hard to find. So you simply answered the gentleman that he will just be returned with no service. But then if I may ask, even if you outsource services of people who could track and find, but they find nothing, is there perhaps a limit in terms of days to apply for a default judgment if he cannot be found at all or is hard to find, and you return to court and they perhaps give a default judgment that his whereabouts are unknown, so the order is A, B, and C?
Look, there are a lot of considerations to be taken into account here. One of them is the issue of prescription. If you cannot serve the person with the summons within the required time, that claim against them will prescribe. That's why the duty rests upon you, the plaintiff, to find the defendant and where he's at, where he's residing or where he's hiding, and make sure that you serve him. And there are alternative remedies for when you can't find someone. If they're no longer at the last known address, there's something called substituted service. You have to bring a substitute service application to the court, telling the court that you can't find the person anymore, and that you ask to publish it in one edition of the newspaper that's circulating locally in the area upon that person, so that because you don't know where the last known address is. And if the court is satisfied with those facts, the court will grant you an order for substituted service. But it's still up to you. The duty is on the plaintiff to find out where the defendant is.
Okay, thank you, advocate. But
thank you very much.
Yes, but maybe the other part of the question was, so you mean that there's no set of time to say if for this long this person can't be found, and this is a remedy that could possibly be availed to you. For an example, they cannot do that.
No, you cannot, because if you are unable to serve summons on the person, you are not entitled to default judgment until you've done so. So you must serve on them first. Otherwise, you're not entitled to the default judgment. And if you don't ever get hold of that person, your claim prescribes and you don't have a cause of action.
Thank you so much, advocate.
My pleasure. Thank you, all of you, for your kind attention. Please make an effort to read ahead tomorrow. We will start again, and then hopefully we will be able to cover some more ground. But I think we did well today in terms of catching up from last night. Thank you. Have a good evening and a good day tomorrow.
Sir, before you close.
Thank you.
just
Have a good
question.
evening,
Thank you.
Advocate.
Thank you.
Sorry?
I was just saying, just on the last question that was asked about if you're not finding your defendant, and you said that you just said we can use substituted services, isn't like newspaper, and since newspaper is no longer as popular and you are not even sure if they read it or they
not one kind of
what happens, because nowadays we mostly use the internet, we mostly use social media.
You can even ask that instead of the newspaper, you post on their Facebook page. They were last on Facebook 2 weeks ago or a week ago. The Facebook account is active, but you must make those allegations. Or you can even ask to serve them via WhatsApp, because WhatsApp gives you blue tick, and then you can check on WhatsApp whether they've been served.
Oh, hey, but nowadays WhatsApp doesn't give blue tick because you can do that read receipt where you can hide if you see people's profile.
You'll have to find
anything.
a way around it, eh?
It's complicated.
Yes. Fine.
Yeah.
Thank you.
Okay, thank you.
So what time are we starting tomorrow?
5:30.
Thank you.
Thank you.
Thank
you.
Bye. Thank you.
Thank you.
Hey.
Thank you, Advocate.
Thank you. Thank you.